Good evening. Today is August the 11th, 2021, and we are now holding the City of Gaithersburg Board of Appeals meeting. I'm calling the meeting to order, and I would also like to welcome Sarah Yassin as our alternate this evening, who will be sitting in on all matters before the board this evening, as that she's serving as an alternate for one of our absent board members. So thank you very much, Sarah. Okay, and I'd also like to point out that there are no minutes to approve this evening, and we'll capture those in a future meeting. Okay, the first item on the agenda is a public hearing, and it's actually, let me go ahead and read it. It's BOA 8938-2021. It's a request for a 6-foot variance of the 30-foot rear yard setback at 720 Tiffany Court in the R90 medium density residential zone. At this time, I'd ask Caroline Seiden to go ahead and present the case before the board.
Good evening, everyone. This is a public hearing on Board of Appeals case BOA 8938-2021. The hearing was published in accordance with the requirements of the city charter and code on the city's website, and the property was properly posted. At the present time, there are 15 exhibits in the record files. They are referenced in an exhibit list in the files. The individual exhibits may be reviewed during the course of the meeting or in the Planning and Code Administration office during regular business hours at City Hall or on the city's website. Any objections to the receipt of any exhibit should be noted prior to the closing of the record. Otherwise, they will be deemed received in evidence. If we can put up packet page number 3, please. This is the aerial. The applicant is requesting a 6-foot variance of the required 30-foot rear yard setback requirement in the R90 zone as required by section 24-32C of the zoning ordinance, chapter 24 of the city code at 720 Tiffany Court, lot 9, block C, Diamond Courts, Gaithersburg, Maryland. You can see in blue, the house is outlined on Tiffany Court at near the intersection with Hope Lane, and in the vicinity of Quince Orchard Boulevard, which would be the most major road close by. The property owner, Hugh Gwen, is here to present his case to the board. So I will turn it over to Hugh.
So Hugh, before you start, thank you, Caroline. I'd like to swear you in as a witness. And if you just want to raise your hand, and do you solemnly swear and affirm under the penalties of perjury that the testimony that you're about to give in this matter shall be the truth and nothing but the truth?
Yes.
Yes. Okay. Thank you. Please go forward.
We can go to page 4 also while.
So first of all, I would like to thank Mr. Mann and Ms. Silent for all of your help with the case to present to the board. And thank you everyone for the opportunity to present the case to you tonight. On this exhibit, as you can see, that the lot is in a very obscure position where the house is not completely square parallel to the lot and is facing it in the corner. And can you go to the next slide? As you can see right here, the setback of the house very close, right on the 30-foot setback to the property line when it was built. And so when we purchased the property, the deck was there, and there was existing deck, as you can see on the next slide. Next slide, please. Yep, this is the old deck, which already existed before we updated deck. It was rotten and collapsed. As you can see, the stairs going down from the deck already extend beyond the setback 30 foot setback. So we did the deck, we the stair direction. Can you go to the next slide?
Is he frozen?
I actually don't see the next slide. Here you can see that basically we update the material on deck and we turn the stairwell to the stair to the other direction. As a matter of fact, it turns out to be shorter than the original stair, whereas extend beyond the 30-foot setback. And by doing so, we now have a 5 feet 9 inches into the setback. And this is the application where we ask for the board for approval, grant the permission for the variant for that 6-foot extension. So we don't have to make any change or modification to this. And from the work has been done, and I personally don't believe it's have any environmental or any damage to the existing or current neighbors around the community. As a matter of fact, the stair itself is shorter than what it was before. Next slide. I think this is the last slide for this package.
I think there's one more after this.
Yeah, here we can see the comparison between the two stair that's coming down. And the side of the deck is exactly identical to the old deck. We just updated material, so it's no longer replaced on the rotten piece of wood and replace them with the maintenance-free material. The size of the deck remained unchanged. And surprisingly to us, the previous owner, when he built that deck, I tried to ask the city to see if there's any existing permit, and that old deck did not have a permit either. Next slide. We saw this one already. So I think at this time I see if the board work on or application.
Is there any other description that you'd like to present to us, Mr. Nguyen?
I think this is all I can show and present. The difference between the two stairs, and the difference is the 6 foot, the 5 feet 9 inches. We are into the setback.
Okay. Okay, thank you very much for your presentation, Mr. Nguyen. I'd like to now open it up to the board to see if they have any additional questions regarding this request for a variance. So I'll just kick it off with a question. So it's my understanding that the pictures that we're seeing now, aside from the very first one, which was a picture of the old deck, that the new deck has already been built, so we're requesting the variance now on the built deck. Is that correct?
That is correct.
Okay, thank you.
I did have a question for Mr. Nguyen. Have any neighbor comments been received from those neighbors identified on package page 38?
I haven't received any.
Okay, so I heard that you said that no comments were received on this variance request, correct?
That's correct. Would there any objection?
Okay, thank you.
Unmute. Robert, do you have any questions?
No, I just know that neighborhood very well, and I know the backyards are very difficult to deal with. And what he put up there is a much better improvement from the original one. So, it looks fine. I wish more people would do that, fix up their decaying decks.
Okay, thank you. Thank you, Robert. So Gary, do you have any questions?
No, I echo Robert's thoughts on I think it's a great improvement and you're probably a welcome new neighbor.
Okay, thanks. And Sarah, any questions for Mr. Nguyen?
No, I agree. It's a great improvement. It's a shame that the builder didn't do the 30-foot setback instead of doing, like, he did 33 feet. So I don't understand why he did that but anyways, I think it's great.
Okay, all right, thank you. Okay, so if the board doesn't have any additional questions at this time, then I believe then we can go right into, or do we have any additional testimony from any other parties this evening on this case?
I may want to, Madam Chair, I may want to make sure there's no public comment. I don't know if there's anybody else from the public or not.
Okay, that was, I guess, my question. Is there anybody else here in the public wanting to provide comment on this case?
I think maybe we should, there's a video that we should play to instruct in case there is somebody that wants to participate. I don't think that there is, but just have the tech team play the video so that anybody that wants to participate will know how.
Okay,
Go ahead and do that.
Okay, great. Thanks, Caroline. We'll watch the video now.
Okay.
Good evening. If you've connected to the meeting tonight via Zoom and you're on a desktop or a laptop and you wish to make a public comment, we can't currently see or hear you. What you need to do, please, is wiggle your mouse around and look towards the bottom center of your screen. You should see a raise hand button. Go ahead and click on that now for us, please. Alternatively, if you've connected in via telephone, you can press *9.
I do not see any attendees with their hand raised.
Yeah. Okay. Carol, you're on mute.
I lost my screen. You think after all this time I wouldn't happen, but it does. So, okay. So, all right. So I don't see any public comment this evening. There's no one we haven't been notified as the board that there's public comment because this is a hearing. So let's go ahead and close the record. I'll need a motion to close the record.
I make a motion to close the record.
And a second?
I second.
All right, so now this is the time where we have additional board discussion regarding the draft resolution that's in our packet. Do we have additional comments? I have just a couple of comments for our discussion this evening. But I'd like, if there's any other comments to please, from the board members, please go first.
None for me, Carol.
Okay, all right. Okay, so looking at the packet there, I thought that the presentation of all the different photos of the past deck as well as the new deck, definitely an improvement. It looks like it's a very shallow and an unusual shape of the lot, which is a factor in for us as the board to approve a variance in this case. And it appears that just from the discussion that there was no impact from the neighbors. Is there any additional comments that the board would like to make? Okay, well, let's go ahead and call for the resolution. I'll need a motion. And this would be, let me see if I can find this. This is in your packet. And I'll need someone to present the resolution, packet page 45.
Yeah, I can do it.
Thank you, Robert.
Now therefore, be it resolved by the Board of Appeals of the City of Gaithersburg on the 11th day of August 2021, that case BOA 8938-2021, the petition of Hugh Nguyen requesting a 6-foot variance of the 30-foot rear yard required in section 24-32C of the City of Gaithersburg zoning ordinance for the maintenance of the deck stairs at 720 Tiffany Court, Lot 9, Block C, Diamond Courts, Gaithersburg, Maryland, be granted.
And I'll need a second.
I second it.
Okay, and in order to take the vote, because we're virtual, I'll need to do a roll call. So I'll just call you by your first name. Robert, how do you vote?
Aye.
Sarah?
Aye.
Emil?
Aye.
Gary?
Aye.
And myself, aye. The resolution passes. The motion passes 5-0. And that concludes that. All right, so let's move on to the second item on the agenda. And this again is a public hearing. And this evening we have public hearing and it's BOA 8959-2021. And it's a special exception for a rooftop telecommunications facility at 506 Main Street in the mixed use development zone. And Caroline, could you please present the case before the board? And you're on mute.
Apologize. This is a public hearing on the special exception case BOA 8959-2021 for a rooftop telecommunications facility at 506 Main Street, known as the Lakeland's office building. If we can put up Ariel packet page 49. The hearing was published in accordance with the requirements of the city charter and code on the city's website, and the property was properly posted. At the present time, there are 20 exhibits in the record files. They are referenced in an exhibit list in the files. The individual exhibits may be reviewed during the course of the meeting or in the Planning and Code Administration office during regular business hours at City Hall or on the city's website. Any objections to the receipt of any exhibit should be noted prior to the closing of the record. Otherwise, they will be deemed received in evidence. The applicant requests a special exception for a stealth rooftop telecommunications facility at 506 Main Street, which is also known as the Lakeland's office building. It's shown here on the aerial between Market Street East, Market Street West, and residential Devon Courts to the south and City Park just to the north of the office building. The subject property is zoned MXD, mixed use development, pursuant to section 24-167A D2 of the city's zoning ordinance. Telecommunications facilities are permitted as a special exception in the MXD zone. Additionally, Because it is located adjacent to residential uses, staff has determined that this site is in a residential MXD zone, and therefore the requirements of section 24-160D5B, which states that all telecom facilities in residential MXD zones must be enclosed in existing structures, applies. The applicant went before the Planning Commission on August 4th, 2021 for recommendation, and the Planning Commission recommended approval with 5 conditions as included in Exhibit 19. I'm going to turn the presentation over now to Doug Sampson, who is here representing the applicant. The applicant is AT&T, and I'll let Doug make his presentation.
So thank you, Caroline and Doug, and any others on your team that are going to present testimony tonight that are not attorneys. Would you please raise your right hand? And I'm just going to swear you in all at once, okay? So do you solemnly swear and affirm under the penalties of perjury that the testimony you are about to give in this matter shall be the truth and nothing but the truth?
I do.
Okay, thank you. Okay, great. Thank you very much. Please proceed.
Thank you, Madam Chair and members of the board, and thank you for your time this evening. Really appreciate it. Again, my name is Doug Sampson. I'm an attorney at the law firm of Saul, Ewing, Arnstein, and Lear, and I am the representative here tonight for New Singular Wireless, PCS, LLC, which I'll also refer to as AT&T, which is the applicant for this particular application. I do want to thank the staff. They've been wonderful throughout this whole process, helping coordinate. They put together a fantastic staff report and really did a nice job helping to coordinate and run tests yesterday to make sure that all of our Zooms were working. And so they've just been wonderful to work with. If we can go ahead to the first slide of the presentation. This is a rooftop telecommunications facility proposed at 506 Main Street in Gaithersburg. It will bring expanded and improved wireless services to the Gaithersburg area, including something called FirstNet, which if you're not familiar with it, I'll get to that in a few minutes. This facility is designed to match the existing building facade, which will virtually eliminate any visual impact. And we do have some visual impact simulations we can show you in a little bit. The site will comply with all federal, state, and local laws and regulations. And we are applying for a special exception. A rooftop telecommunications facility, as Caroline said, is permitted in a mixed use. And we're applying for with a special exception, which we're applying for under City Code sections Article 7, Section 2489, and Article 4, Section 24167A. Next slide, please. So the goals of this site are to bring reliable wireless services to the city of Gaithersburg. This includes both emergency and non-emergency wireless access and broadband services. This is part of the FirstNet network. That is a dedicated broadband for use by first responders and public safety officials. It was something created during the 9/11 Commission following the September 11th attacks by the United States Congress. And they passed this to prevent the issues that first responders had on that day, not being able to get through with cellular networks and coordinate their response. So this is a federal contract that is exclusive with AT&T and is offered at all AT&T sites for first responders. The other goal is just to bring reliable services that support ongoing increased wireless usage, such as this evening, working from home, in class and virtual learning for schools, telehealth, online worship services, and virtual meetings like the one we're in this evening. Next slide, please. So FirstNet is, again, an exclusive contract with AT&T, and it's, again, dedicated network access and bandwidth for first responders. They also have deployable assets to boost coverage where needed. And we've really seen the efficacy of this program through the COVID-19 pandemic. During COVID-19, federal agencies, over 13,000 of them, federal, state, and local agencies across the country, have used 1.5 million daily connections to help respond to ongoing situations, many of them related to COVID-19. In fact, you may remember when the pandemics first began, there were 2 Navy hospital ships that were in New York Harbor and LA Harbor, and both of them used all FirstNet for all of their ship-to-ship communications and ship-to-shore communications. Next slide, please. I do have 3 witnesses with me this evening. For the efficiency and time's sake, I will proffer their testimony and say that everything in our application materials and exhibits remains true and correct to the best of our knowledge, information, and belief. But if the board does have any specific questions for any of our witnesses, once I'm finished, they're happy to answer them. Along with me tonight is Ryan Triller. He's a real estate specialist with SmartLink LLC. They're a contractor for AT&T that help with real estate site acquisition and development. Camille Shabshab is the professional engineer on this site. He prepared all of the site plan drawings and can also speak to the visual impact simulations that we performed. And Gaurav Bell is a radio frequency engineer with AT&T. He could speak to the coverage goals and also capacity and the coverage maps that we'll see here in a moment. Next slide, please. So this is a look at existing coverage. So the green area is what AT&T considers good coverage for both in building, in car, or outside. And the area that we are trying to fill is labeled Connolly right there in the center of your screen. That is where this site would be on Main Street in Gaithersburg. If we can go to the next slide. This would be the proposed coverage once the facility is up and operational. So if we could just real quick, just so the board can get a look at this, I'd like to go back one slide. Again, this is existing coverage as it is today. And then forward one slide. This would be proposed coverage with the new facility from AT&T. So this would bring significantly increased services, especially in-building services, really to the Kentlands Market Square along Main Street, Kentlands Boulevard, and Market Street right there in downtown Gaithersburg. Next slide, please. As part of our due diligence, we did look, as the code requires, within a mile radius to see if there were any co-location opportunities instead of having to build a whole new site. There was only one existing telecommunications facility within the mile radius that had any space left for co-location of telecommunications equipment. That's an SBA tower, and what you see here on your screen is the mile radius. The yellow pin at the center of the circle is where our proposed facility would be on Main Street in Gaithersburg. And over to the right, if you look at the number 1, that is the existing SBA tower as it currently exists. And I just want to kind of point out, you can see, I think that's Highway 119 right there. That is just to the left. It's between the two sites. And if we can go back one slide, you can also see here. Let's go back one more slide, actually. All right, so you can see the highway right there to the right of the coverage area. So just kind of giving you some context of where that SBA tower is. It is over almost where the mouse, or over where these bodies of water are on the other side of the highway. And so it really is pretty far outside of the hole that we are trying to fill in the existing network that you see here today. Next slide, please. So these I'll run through fairly quickly. These are in your packet. These are just the site plans that have been prepared as part of this site. This is just the title page that has a lot of the zoning and site information. Next page. This gives you a look at the overhead. So this is the building here indicated by the number 1. Just below that 1 is the building at the site where at 506 Main Street. And where we are proposing to put this. And as you can see, it's right kind of in the middle of everything, Main Street and Market Street there, as far as the targeted coverage area. Next slide. This is a look at the rooftop equipment plans. So what you can see here is there are 2 shaded rectangles, one in the center at the top and one at the center at the bottom. And this is where the antennas will be. Now, the reason that there are 2 is to provide the adequate coverage for the targeted area, you need antennas pointing in 360 degrees to cover the whole area to maximize the coverage from that site. We did consider putting everything just into one shelter instead of splitting it up into 2. There were 2 reasons that we decided to split it up into 2. For one, the shelter would have been much bigger, and we felt that it created a larger visual impact than splitting it into 2 smaller shelters. And the second reason was structurally. The larger shelter would be more prone to winds and some other structural issues that might be caused by weather. And so it was safer and more structurally sound to actually split this into 2 smaller sections. And that would enclose the antennas. Next slide, please. This is a look at it from the side and from the front of the building. You can see the what it would look like from the front. We'll have some photo simulations in just a moment, but this is the proposed location on the building of those two facilities that would enclose the antennas. Next slide. Again, these are building elevations from the opposite side. This would be from, I believe, the north side, so the front of the building and the east side of the building. Next slide. So here is a look at the proposed visual impact or proposed view of this. So the existing view is down in the bottom left, and it may be small on your screen. These are also available in the packet as part of the exhibits. So the existing view in the bottom left, you can see obviously there's no equipment shelter on the top. In proposed view 1, it shows the equipment shelter, which will be designed with materials to blend into the building facade. And one of the 5 conditions which was discussed with staff and the Planning Commission, which has been accepted by AT&T, is we're going to provide staff with these materials that will be used to stealth, to enclose this facility, so they can examine them and make sure that they work before we build anything, to make sure that they will in fact blend in with the building, that they'll wear the same way the building does, and things like that. So that is one of the conditions, and AT&T is happy to do that as part of this project. Next slide. Here's another view, kind of from the front. Again, in fact, let's go to the next slide, which I think really shows how this is designed to blend in. So you can see on the top there, the existing view and then the proposed view. This will be designed not only in color, but also in design and texture to really try to blend in and look like part of the building, which really reduces the visual impact to almost nothing, especially in the residential area, which Caroline discussed. We're following the code to make sure that the antennas are completely enclosed because this is a residential area despite being mixed use. And we think that this is a really good solution that really puts very little visual impact on the community. Next slide. And then here's another view. I think we have 5 total in the packet. Next slide. And there's the final view. I believe that is all of the slides that we have. I would just ask that the board adopt the Planning Commission's unanimous recommendation and the staff approval or recommendation for approval. And we ask that you approve this special exception to build the rooftop tower at 506 Main Street in Gaithersburg. And like I said, myself or my team would be happy to answer any questions that the board may have this evening.
Okay, thank you very much, Mr. Sampson. That's wonderful. Okay, so I'll go ahead and open it up to the board for discussion. All right, I'll be glad to kick it off. And I don't have the packet page, but it would be the one with the architectural design, one of the last slides that we just saw. Let's see here, I have a question on that. Let me see if I can find the.
We can go to, well, I don't know which one you want, but we could go to page 64 as one of them.
64, that would be fine.
You can go forward or back from there.
We could just put up page 64 here. Okay, great. So the question I have a couple of questions, but I'd like the board, if they'd like to ask questions too, to please, we'll go ahead. So my one question I'm just going to ask now, in looking at the proposed view 3, will that crisscross design that's on the, I guess, the container, the case for the equipment there, will that go all around? Will that be on all 4 sides or just on the sides that are facing the street or the sides?
I believe it is planned on all 4 sides, but Camille, do you know the answer to that? Camille, again, is our engineer from Entrex, who's been developing the site plans and design, and also helped us a little bit with the visual impact. So Camille, I don't know if you know that answer offhand.
Yes, it will be the same all around.
Okay, great. Thank you very much. Okay, that was one of my questions. So I'll turn it back over to the board for additional questions.
I guess I can go next. Quick question for you, Mr. Sampson. So you have black and white side views, but I never saw a color side view. Do you have one of those?
I think the 5 photo simulations that I showed you are the only ones that we have. And it's because we took actual pictures. And so the way it's laid out with the buildings in that particular area, you can't get a view directly from the side unless you're actually standing on top of the building next door. If you're standing in the street below, you actually would be so far away, you wouldn't be able to see, just because of the angle of the building. If you were directly to the east or west of the building, you wouldn't be able to see these rooftop facilities. And so we tried to take these photographs at kind of this angle to show the side angle view. Because again, I think if you were at 90 degrees to the building, you wouldn't actually be able to see these because you'd be blocked by the building itself.
And there's going to be no antenna views at all.
That's
Just
correct.
to kind of confirm that, I think you've answered.
Yes. So the material that is used that will blend in with the building is actually specially designed to allow the wireless signals to go through the material itself. So these will be completely enclosed. You will not see any antennas. Actually, if we go back 3 or 4 slides, maybe to like 58. No, 2. Go ahead 2 to 60. All right. So if you look on the bottom of the page there, you will actually see within that structure up near the top of it, there are 4 rectangles vertically. That depicts the antennas that will be inside that structure. So that shows you where these antennas will be, but they will not be visible from the outside of the structure itself.
And if there's any communication issues and all of a sudden it just determined that, maybe these need to be uncovered, I guess that would have to come back to the Board of Appeals.
Well, that would be my understanding, because the code is pretty clear that for the area we are, they do need to be completely enclosed. And so my feeling would be if that was determined, that we would be back here before building. Yes.
Yeah, if you ever want to do any work at the Gaithersburg, I think it's the Hilton now. There's a bunch of those little antennas all over the place. And so hopefully we'll avoid any of those kinds of things in the future, maybe clean up areas that were approved prior to, the new, I guess, code or standards, for lack of a better word.
The different zone.
Yeah, I know. Yeah, but same idea. You see the little antennas everywhere. But thank you. That's it. I'm good.
Thank you.
Thank you, Gary. Let's move on. Robert, do you have any questions? And you're on mute. Robert, you'll have to unmute. You're still on mute. We still can't hear you. Okay, now we can.
Okay, sorry, I did it automatically. No, I was just gonna say, no questions, just appreciate, from seeing all these applications over the years, that the applicant has come well prepared with, all the updates and everything that they need to come before the board to get these things passed quickly and more efficiently than taking 18 months like some of them have done in the past.
Thank you. We appreciate that. We don't want to take 18 months either if we can avoid it.
Great. So thank you, Robert. And we'll move to Emil. Do you have any questions that you'd like to ask?
I do not have any additional questions. I otherwise agree with the negotiations with the petitioner and the staff recommendations and proposed conditions.
Okay, thank you. And Sarah?
I second it, and I think I wanted to do AT&T, but my house didn't get the reception, so I think it's great that maybe I'll switch over to AT&T because I live in the Catlins, and so I saw the map and I'm like, oh, maybe I can switch now. So I appreciate that.
Okay, thank you. Thanks, Sarah. So speaking of the map, could we put up the packet page 55?
Mm-hmm.
Oh, okay. So this is so so the question I have, Doug, on the coverage here, and this is going to be after the antennas are, are put into the building. Will I see that before there were some holes, but now that it's all green, will that provide improved coverage for the existing coverage that was there, or will it just be covering just where the hole was?
So it should also provide improved coverage for the overlapping areas, but for coverage, I'm going to go to Gaurav Bell, who's our AT&T RF engineer. He can speak much more intelligently on your particular question than I can.
Okay.
Yeah, sure. Good evening. As you said, where you have to do a comparison between the previous slide and this slide, but where there is already any coverage and it is close to the proposed rooftop, that will see a significant increase in coverage. So in layman terms, if you have 1 bar, you will see 4 bars. If you have a speed of 1 meg, you will see 10 megs. So as long as you are close to the location, even if it's green, you will get significant improvement.
Okay, thank you very much.
Yeah, sure.
And so then this is more just a curiosity question, back to the applied materials that are going to let the signal go through the actual case that it's in. Are those materials like common, or is that something that's going to be special for this particular case in order for AT&T to actually build what is being requested by the city staff?
So I know that stealthy materials in general have become more and more common as it's gotten more and more challenging to locate these in denser areas. But as to the specific materials here, I think maybe Camille or Gaurav would be better served to answer your specific question.
Okay.
So I'm sorry, what's the specific question again?
So the question really is the materials that are being used that allow the signal to go through. It appears to be an enclosed container for the equipment, but the materials they're permeable, is for the lack of a better word for myself. Are those materials, those building materials, are they easily accessible, or is this something that's new to the industry to provide this type of enclosure, as opposed to, let's say, things that were done in the past? As a board member, we've seen a lot of steel containers type of equipment, or type of containers to house the antennas.
The material is not new. It's been in use for maybe 15, 20 years. I mean, it's been in use for a long time. It's basically 2-inch thick rigid insulation panels. It's very similar to the ones that are used on roofing. And it has a skim coat of plaster, and that's what's used to give it the texture and the color to match, whatever it needs to match. So it has a little bit of not only texture, it has also some relief. So the joints are set in a little bit. It's not a flat piece. I mean, the indentations are not large, but there is some. So it has a texture and a pattern actually to it.
Okay, all right, thank you very much. It's very interesting. Okay, so I don't have any further questions. And I'll ask if the board has any last questions for our petitioner this evening. Okay, hearing none, I am then going to go and, we have to ask if there's any questions from, additional questions from other parties such as the public. This is a hearing. So Caroline, should we play the video? And you're on mute. Oh, Caroline, you're still on mute.
I'm sorry. Everybody that's in attendance, that I believe is for the next hearing, and I don't see any hands raised.
Okay, all right, thank you. So then let's go ahead and have a motion to close the record. That would be coming from the board.
Motion to close the record.
And we'll need a second.
I second.
Okay, so we're going to go ahead and close the record now. And so this is where we have our board discussion. Are there any additional comments that we'd like to discuss as a board?
Not here.
Okay. Okay, the only comment I have is that I think it's great that these types of equipment can be placed into a mixed use zone, but for consideration, this is considered to be residential and to provide the necessary service for emergency responders that they'll need in order to perform their duties. And we don't think it's going to happen, but things do happen in our lives, so which require emergency services. So I think it would be an asset then also to the community.
I agree with you, definitely.
Definitely, okay. All right, any other comments? If not, we can go ahead, and it's packet page 184. I think it's 164. Hold on one second. I'll need a board member to offer the resolution.
Is that where we make a motion to close the record?
Well, actually, Gary, we already closed the record, so now we're going to present the resolution for the board to vote on to accept this special exception. And that would be on there, that would be on packet page 164.
I can't if no one else is, I'm on the page, so.
Please, Robert, please go
Okay.
forward.
Okay. Now therefore be it resolved by the Board of Appeals of the City of Gaithersburg on the 11th day of August 2021, the case BOA 8959-2021, the petition of Ryan Triller on behalf of New Singular Wireless PCS LLC, doing business as AT&T, requesting a special exception to construct a rooftop telecommunications facility consisting of 12 panel antennas and related equipment in the mixed-use development zone on Block Q, 506 Main Street, Gaithersburg, Maryland, be approved with the following 5 conditions.
Okay, thank you. And do I have a second?
Second it.
Okay. Is there any further discussion? Okay, if not, then I'm going to go ahead and I have to do a roll call vote because this is a virtual meeting. And so let's see, we'll go ahead with, let's see, Robert?
Aye.
Emil?
Aye.
Gary?
Aye.
Sarah?
Aye.
And myself, aye. And so the motion passes 5-0.
Thank you all very much for your time and
Okay,
consideration.
thank you very much. Thank you very much. All right, so we're going to now move on to our next item on our agenda. And I am going to make a few statements before we start here. Well, actually, we're going to start and then I'm going to make the statement. So we're going to have a little bit of a different, not a different format, but a format, and where I'm going to announce the reconsideration, and then I'm going to ask Caroline to do the introduction. I'm also going to ask Frank Johnson to provide additional comment, and then we'll hear from the petitioner, Diamond Farms Board of Directors, as well as the Restoration Chapel. And then we will then have a discussion as a board for this reconsideration. And you can also ask the questions to the petitioners too. All right, so with that, the next item on our agenda, it's reconsideration requests, and it's BOA 8796-2021. It's Peter Acheampong for the Restoration Chapel International, special exception for religious use at 841 Quince Orchard Boulevard, Suites A and B in the C1 local commercial zone. And so Caroline, could you go ahead and present what was received? And then I'm going to ask Frank to also comment.
Just a brief background. At its July 14th, 2021 meeting, the Board of Appeals approved special exception BOA 8796-2021 for religious use at 841 Quince Orchard Boulevard, Suites A and B, to Restoration Chapel International. The resolution of approval included 6 conditions, some of which the board included to address issues that were raised by the Diamond Farms Condominium Association. On July 29th, 2021, planning staff received a request for reconsideration from the Diamond Farms Office Condominium Board of Directors. The board forwarded this request to the applicant on July 30th, 2021, and the applicant filed a response on August 6th, 2021. The president of the condo board of directors, Tom Curtis, is here, and the applicant, Peter Acheampong, on behalf of Restoration Chapel International, they're both here this evening. So I just wanted those dates in the record.
Okay, thank you, Caroline. And Frank, could you provide some commentary on what we've received?
Sure. I'll make a few introductory comments and then get right into the heart of this. The first comment I do want to make is and this is really for the benefit of everybody, is that the board's in place to consider the city zoning ordinance and special exception standards and conditions under section 24-191, not really enforcing specific condo rules or anything like that. That really falls to the condo association. I think the board members understand that, but just to set the record straight on that issue. Second of all, a motion to reconsider, and this is the condo board's motion, can be granted for really a couple of very delineated, careful reasons. A legal error, such as a legal mistake, such as interpreting the city zoning ordinance, a factual error. For instance, if there was a presumption something would happen that will not. If there's new evidence that's relevant to the decision. Now, that doesn't mean any new evidence, but that means evidence that would be relevant to the decision. And the last one is really if the board finds it a compelling reason to go ahead and reopen, then the board has the ability to do that. The underscoring point there is the board really does have quite a bit of authority here. And that gets into my third major point, which is as part of the motion, it does fall to the condo board. They have the burden to show what is the reason for their motion, what supports it. And it's fair for the board to ask them to specify, first of all, the person is speaking for the board, but what is it they're seeking? What's the bottom line? And that can be simply clarification of the existing order. It is possible that there's a question as to the meaning of that. We can certainly do that. If there is a change to a condition, there were 6 conditions. And if board members remember the discussion just last month, there was some concern to make sure to address condo board concerns that were relevant to the city zoning ordinance. So if there was a way to address those concerns, well, if there are additional concerns, that could be part of a request here, not just to reopen, but change the condition. Lastly, it could be a new hearing. Now, again, if it's a new hearing, though, that does require some sort of an error, legal or factual, some relevant new evidence, or some other compelling reason. In terms of what to do tonight, and that's really the fair, let's cut to the quick question. The best process is, first of all, once we're done with the staff introduction, it can be important to go ahead and reopen the record to include the initial request as well as the response and tonight's discussion. No matter what the outcome is, having the record include this discussion as well makes sense, and simply to reopen to include all of this is appropriate. That may be closed again, depending on the outcome, but at least starting would be my recommendation on reopening. After reopening, then just in terms of process, because my understanding is this is the first motion you've had, at least, shall we say, in some time. It's the condo board's motion. You have a representative here, Mr. Curtis. Let him make his argument or indicate what they're seeking, what the condo board wants to see. Again, that could be clarification, a change of a condition, or a new hearing, and then the basis for that. After that, the board may have some questions, but certainly let the church representative, the applicant, also respond. And at that point, the board would really have three options. You can come back to me at that point if you want, not that you have to remember everything, but it can be a simple, if it's a matter of clarification, that may be a discussion and no actions needed. However, if it is a matter of changing the original order, that can be revised. Simply make a motion to revise the order to change the condition. If that does happen, then the July order would be revised and the new order would start with the signature, which might be tonight or tomorrow or whenever, on the new order from August 11th or August 12th from now. If it's a motion to reopen, that's going to be a matter of setting a new hearing date. Your decision tonight won't be on the ultimate issue in that case. It would simply be a matter of saying, okay, we'll go ahead and reopen. I will advise it'd be important to delineate the reasons for that so that the record shows that, but we'll get to that at that point. That could be September, that could be October. It's also possible after discussion, certainly a motion to deny. And if there is no motion at all, then there would be no change in the order such that the July order would remain in place. And if there is a motion to deny that passes, that's also would be that you just decide not to make any changes. I can certainly answer questions as we go through, but in terms of starting here, my recommendation would be first to reopen the record to include the letter and the response regarding the motion for reconsideration, and then really turn to the chair to essentially run the rest of the meeting and really have the parties speak to the motion and then the response. And I'm happy to answer any questions now if you have any.
Okay, so thank you, Frank. So would we need to reopen the record to hear?
I would recommend it.
Recommend
I would
that?
go ahead and do that. Go ahead and reopen it now, even
At
before
this
your
time?
discussion.
At
Yes.
this time, okay. So I'm sorry that if I cut off any board members, are there any questions for Frank on what was just presented?
So a quick question, Frank. So is it my understanding that it would be the condo board's burden to provide a basis on the zoning ordinance that they're seeking the reconsideration on?
Overall, yes, it's their burden. Now, it doesn't necessarily be a legal issue. It can be factual error or something like that. And really, even before you get to that point, the condo board does need to delineate, I would recommend, suggest, what is it they're seeking with the motion? Because I'm not sure the letter that was submitted did identify a couple of issues, but it wasn't clear where they wanted to go with that. So, yes, you're very correct. Anybody filing a motion or pursuing an application, that's the person that has the burden.
Thank you.
Any other questions from the board to Frank? Okay, so at this time, I'll ask the board for a motion to reopen the record.
I make a motion to reopen the record.
And a second?
I'll second.
Okay. So Frank, at this time, now we can go ahead and ask for Diamond Farm Board Condo to present, as well as then afterward, the Restoration Chapel.
Well, I'm assuming that was constituted a vote to reopen because we had a motion and a second.
Let me go ahead. Let me call
Just to
for the
make
vote.
sure.
Let me call for the
Understood.
vote there.
But
It's
before you,
different virtual than in person.
Yeah.
before you take a vote, I just wanted to suggest that we have for the record a statement from Sarah, whether or not she's reviewed last month's meeting so that she can participate in this month's meeting, in this vote.
I reviewed it. Yes.
I just wanted to get that on the record.
Okay,
I
thank you.
believe she was present for the meeting, wasn't she?
She was at the meeting. Yes. Go ahead. I'm sorry, Sarah.
I was present.
That's
but
right, you were.
I didn't participate.
No, but you did observe the hearing at the same time as everybody else did.
That is correct.
Okay, thank you. Thank you, Caroline. Anything else before I call for the vote? Nope. All right. So again, I'll have to go by roll call. So I'll just go on the screen here. Robert, how do you vote?
Aye.
Gary? Emil?
Aye.
Sarah?
Aye.
And myself, aye. The vote passes 5-0 to reopen the record. Okay, now Frank, now we have the vote. Moving forward, now, would this be where we have both the Diamond Farm condo present as well as Restoration Chapel after they're finished?
Yes, this would be the part, unless there's any other statement to be made by staff, which I don't think there is. Time for the Mr. Curtis to present. As I indicated, first of all, what it is they seek, and then talk about the grounds for that.
Okay, all right. Thank you, Frank. All right, Mr. Curtis, thank you for coming to the meeting this evening. And as you've heard from our discussion, would you please present your letter that was sent to us, to the board as the July 29th, and what you're seeking?
First of all, I'd like to thank the board and especially Frank for outlining all of the different issues that are involved. And, you know, Diamond Farm is a professional park. It constitutes lawyers, doctors, accountants, insurance agents, and other people of a similar ilk. And the proposed use of this unit does not really fit into the concept of a professional park. My understanding, excuse me, I've got a summer cold, so you'll have to excuse me. My understanding from the meeting last month from one of my board members was that the person representing Restoration Chapel testified that they have not been having services in the unit and that there were no cars parked in the parking lot. I'm a CPA and my office is directly above the unit that they're intending to purchase. And I can tell you from January through mid-May, they had services every Sunday and there were lots of cars in the parking lot. So it was being fully used and fully utilized. In addition to which, we were concerned because at some point during or after the services, children were running around in the parking lot. And they were unsupervised. We didn't think that was a good idea because it is it's a commercial parking lot. And we don't want to bear the risk and liability associated with children getting hurt. We believe that we've outlined a number of things that we think should be done if this special exception is to be granted. The first one is that they be required to provide us with a insurance liability coverage for their use and their I guess parishioners, if you want to call them that. Secondly, there is a considerable amount of noise because they they get pretty raucous on Sundays. And we had asked them to put a sound barrier beneath the windows on the one end of the sanctuary to absorb a lot of the noise from the music and the singing. When we did the walkthrough with them maybe 6 weeks ago, they agreed that they would do that. But my understanding is that they have since rescinded that approval. In addition, we want them to control the children who are in the parking lot and also to limit the number of people who attend to 50 people. I believe that the board approved 60, but I'm not sure about that. In any event, I don't necessarily object to them being there. It's not a professional use by any stretch of the imagination, but as they pointed out, this is primarily an office for them. And then on Sundays, they have the services. Although I understand that now they're talking about doing services on Tuesdays and Thursdays. Again, we don't want their use of this property to impinge on the use of other tenants and owners in the professional park. Essentially, that's where we are. I don't know that we're necessarily diametrically opposed to their use. In fact, the board was evenly split on this when we voted on it. So I would just hope that the Board of Appeals, in its ultimate decisions, should they grant the special exception, incorporate some of the concerns that we have with respect to the use of the facility.
Madam Chair, if I can clarify with Mr. Curtis. So based on what I had outlined, Mr. Curtis, and I'm asking just to correct for the board's understanding. It sounds like you are not so much asking for a new hearing, but the incorporation or it might be changes to some of the conditions, but you identified what I thought were 3 additional factors. And I want to be clear so that the board knows what we're talking about and what you're talking about, which would be providing insurance coverage. Again, I'm presenting it for the board and for staff to hear this as well, that they at least have insurance coverage for their use. The noise sound barriers that you said had been previously discussed, and then also to looks like actually there were 4. One was to control children in the parking lot, and then also to limit attendance to 50. That is what I heard that you were interested in. It's not so much a reopening, but asking the board to at least address those 4 specific concerns. And, I'm not sure they were presented as quite as specifically on July 14th. So I just want to clarify with you, Mr. Curtis, am I correct on that? And if so, then.
You are essentially correct. It's noise mitigation is one of the issues. And, as I said at the beginning, my understanding was at the last hearing that the applicant misrepresented, if you will, the use of the facility and the use of the parking lot. So there's an issue there outside of the issues that you're facing now.
Okay. Madam Chair, it might be appropriate now to have the applicant speaker respond if he will, unless there's any, and then I don't know if there would be any other comment, but then perhaps have the board ask questions or offer comment.
Okay. All right. Thank
Ask
you.
for assistance.
Okay. All right. So Mr. Acheampong, would you like to respond to Mr. Curtis and present what and respond? I guess that would be my question. And I don't know if he is on mute.
Looks like he is on mute on my screen.
Okay,
Oh,
you got it?
He just came up.
Okay. Okay, thank you. Yeah, Tom is directly above us. So yes, he can complain about noise. That is right. And we are going to fix that. I think we had a walkthrough and we have discussed it. We're just waiting for the approval for us. We have already submitted the permits and everything so that we can fix that. And then the liability which we are working on, I think it was the scarce. So we are trying to provide that. And basically, everything that Tom said, we will address it. That's something we are addressing, and we assure them that we're going to address it during our meeting with them. So I think that is not that shouldn't be an issue at all. We're gonna address it, and we will. If we don't address it, then I would suggest maybe they can come back to you. But we're gonna address it.
And I would like that to be part of the conditions of the approval, or whatever you can do in terms of making sure that even though he says they're going to do it, that they actually are bound by your approval to do it.
Is there any further comment from Mr. Acheampong?
No, I mean, yeah, you can include it, because if that is what they want, yes, we will abide by it, because we are promised to abide by all their rules. We are not, we just want to be law abiding, and we want to work with them so that, we don't want to be any impediment to any of the tenants. And just as again, Tom is a good friend. We talk to him sometimes, and we know. And as far as he has expressed it, we're gonna work on it.
Okay. All right. Thank you.
You're welcome.
Okay. All right. Now, so I'd like to open it up to the board to ask any questions now to either Mr. Curtis or Mr. Acheampong regarding what we have heard so far.
I have one question for Mr. Acheampong.
Oh, I'll let Robert go first, and then Gary, if you don't mind. Okay, go ahead, Robert.
Was there a service this Sunday?
No.
Okay. See, I live right down the street, and I went by it, just to check things out, and I didn't see anybody in the parking lot, so I was beginning to wonder if there was a service at all. So, okay, thank you.
Okay, thanks.
And the reason, excuse me, the reason was, the last time we had Rob and the fire marshals walked through, and he recommended that we shouldn't have services anymore. So that's why we stopped.
Okay, thank you.
Thanks, Robert. Gary?
A couple questions, Mr. Curtis. What is your title, I guess, with the condo board?
I'm the president of the condo board.
And so a couple things. I guess I got a question. I believe that Peter, sorry if I call you by your first name.
Yeah, that's
he had a letter from you initially, and it actually in that letter, if I can, and maybe I'm misspeaking, but just to confirm it, you had mentioned you actually enjoyed being serenaded by the music and the singing.
That's correct. However, it is really loud, and it does interfere with my other employees who are working.
Okay, we'll take care of that.
So you were speaking on behalf of I guess as an individual, as the president.
That's correct. I was speaking as an individual, not as the president of the association.
But my issue is, I guess you signed it as the president of the association, and that's where I was a little, because at the last meeting there was somebody there in opposition because of the noise mainly, nothing personal with Peter. It's just, but then that letter from you as the president of the association, basically, if the president says he enjoys it, and it was kind of hard for me to but then my next question is are you looking for a complete sound proofing of the condo unit where it's because a friend of mine does this for a living, and you can, there's decimal levels. I'm not an expert, but you can soundproof a building where basically, or a structure inside of a building where no sound at all would ever escape. Are you looking for that? Or, what are you exactly looking for? Because it's kind of, I just don't want to hear it. Doesn't really cut it to me, and maybe to you, but what are you looking for? We have to get into decimal levels really to grant what you're asking for.
Well, we're looking for sound mitigation. As you point out, they could do a complete sound proofing of the entire unit, which would probably be very expensive and probably not really necessary. When we went through the facility about 6 weeks ago, there was a wall underneath some skylights, and we had suggested putting there's a soundproofing material that's used in audio studios and places like that absorbs the sound so that it doesn't go, because what happens is the music and the noise go up through the skylights and then out above and into the other units. So we had suggested putting something on that one wall to absorb the sound and the music so that it's not quite as loud and not quite as disturbing. And with respect to signing that thing, I have to be more careful next time I send out emails to make sure when I'm sending it out that it's got the correct signature.
And then my other question, does your bylaw specifically address sounds penetrating from other units to other units? Because I understand, let's say right now this is fine and everybody's happy, but then you have a business owner that buys into the complex and the bylaws prior to buying, and then all of a sudden, they go to work on a Sunday morning and they, in their opinion, are being disturbed. How do you plan on addressing that for future owners?
Well, there are things. I'm sorry, go ahead.
I just don't want to see the applicant. I was a little late on that. It's my fault, but I just don't want to see the applicant. Here's the gentleman who's running his, for lack of a better word, a church is a business, in my opinion, and everything's going fine. You get a new owner, and then it upsets the applicant. And so I was just wondering how you plan on addressing that in the future.
Within our bylaws, we do have rules with respect to penetrations between walls of units and the kinds of windows that can be used and all sorts of things. And noise levels is one of the things, although I can't specifically remember what the decibel level is on that. But I do know that there is a requirement that the noise levels be within a certain decibel level. But I don't have the bylaws in front of me and I can't tell you what that is. But it's pretty low.
Well, I just speaking on what I've been familiar with, just says any noise that penetrates one unit to another. Most bylaws don't really get into that decimal levels, but maybe yours do. But it just, I'm concerned that, Peter can set up his business and get things going, and all of a sudden, the apple cart's upset on him, really.
I don't think that's going to be a problem.
Okay.
Gary, do you have any additional questions or comments?
No, other than I just think it's very general what Mr. Curtis is saying, and I think that but again, I just hate to see a business owner on either side get put into a situation they don't want to be in.
Okay.
I think this needs to be a little more firm if you're concerned, if that is your concern, noise. Now, if noise was not your concern, then I wouldn't be bringing this up. But if noise is your concern, it's just very difficult to have that on both sides, not, that general.
I thought I was very specific with respect to the noise, and I can tell you that the singing and the instruments and whatnot coming from the unit are significant. They're not, I mean, you could be out on Rabbit Road and you can probably hear them as well.
Okay, thank you. So Emil?
Yes,
you have
Carol.
Yeah.
Yes, I have a couple of follow-up questions for Mr. Curtis. Mr. Curtis, you had mentioned that since the July Board of Appeals meeting, the condo board had a meeting, and you mentioned that it was a split decision. So does the 4 concerns that you raised represent the full concerns of the board and as ultimately agreed upon by the board members in the voting?
The concerns that I outlined were concerns of all of the board members. The difference was that in making the definition about this particular use, 2 of the board members did not feel that having a church was necessarily a bad thing, and 2 of the board members thought that it was. So with respect to the concerns that we had, we all shared those concerns. The only difference was that 2 people thought that it was okay to have the church, and 2 thought that it wasn't.
So would is it the collective board's decision that the petitioner's use would ultimately be acceptable to the board?
Well, I can't speak for the board. You know, you guys are going to have to decide what you're going to decide. Our biggest concern is making sure that the concerns that I outlined are represented in the final approval of the use, if that is to be the case. And very specifically, the noise and the liability issues. The issues of the children running around, that's something that the church is going to have to control. We can't hire a policeman to be out in the parking lot, you know, supervising this.
Okay, and to follow up on Gary's comment, in reviewing the conditions that were adopted on July 14th, with respect to the noise, the condition 6 currently states that petitioner will be mindful of noise levels affecting adjacent units and will take steps to address noise level complaints from such units. And so if there are specific bylaws that would provide more specificity that may help to tailor our consideration of that particular condition, that information would be helpful to know.
I will talk to our attorney and ask him to pull out that language and send it to Caroline.
Okay, thank you. That's all of the questions that I have. Thank you.
I would suggest that again, my first comment was the city board is here, the Board of Appeals, that is, can consider the city zoning ordinance and certainly conditions to the special exception. I really wouldn't suggest necessarily adding in the board bylaws, because that is getting a little bit beyond. I understand the point, but the condition could certainly specify some of the specifics on adding the noise retardant material to the wall where there was an open area. And the other benefit of that is it does sound like the applicant had some awareness of what that discussion was. The other benefit is that because you reopen the record now has that discussion on what, because I know you're looking for something specific. That is a specific change that certainly could be added if the board is willing, is interested in doing that.
And that's the sort of thing that I think we were looking for, was more specificity with respect to the noise.
All right, thank you. And so then I'll move on to Sarah with any questions you might have.
Yeah, I do. Mr. Curtis, I do. I understand your concerns, and you said it was an office park, correct?
That's correct.
Like the whole, so Mr. Peters, I understand that they do services Sunday night and Tuesday and Thursday night or Sunday afternoon. Is that right, Mr. Peter? I can't pronounce your
Yeah,
last name.
Sunday. Yeah, it's okay. Peter's okay.
So I'm just curious, like the noise level, because when I think about an office park, I'm thinking about Monday through Friday, 9 to 5. So I'm just trying to understand why it's so noisy for an office park if it's kind of after hours. I'm just trying to understand. Yeah, I can like, if you guys were doing a church service at noon on a Tuesday, I could understand that, but I'm like trying to get why it's so noisy for an office park. So I'm asking you that.
Well, understand that the office park consists of a number of different professionals. You know, as I said, I'm a CPA and I'm directly above their unit. And, you know, during tax season, I'm there 7 days a week. So anything on Sunday afternoon certainly can be heard by me. Upstairs from my unit is an insurance agent who works on Sundays. And he also told me that he can hear this. So that's just in the one building. You know, with respect to the other buildings, there are people there 7 days a week. It's not just, you know, it's a different kind of economy now. People don't just work Monday through Friday, 9 to 5 anymore. So the office park consists of a number of people who work at various times throughout the week and some on Sunday. And next door to the chapel is a dentist who's there late on Tuesdays and Thursdays. He's there till 7 o'clock. So again, you know, the noise could be a problem for him.
Okay, good. Thanks for clarifying. I just wanted to get that out. Thanks. Makes sense.
Okay. And so the question I have is more on the procedural side, Tom, Mr. Curtis, and because we, as the Board of Appeals, we can only, as shared by Frank Johnson, our attorney, we can only address matters that are special exceptions in the Gaithersburg zoning laws. And so as a result of our meeting that we held last month, July 14th, was that a resolution was passed with certain conditions. So my question is, I'm sure you received a copy of that resolution, and to reconfirm that you're looking for either additions to the conditions or the conditions to be revised to reflect tonight's discussion.
It would be nice to have them revised to reflect tonight's discussion, but at the very minimum, if they could be tightened up a little bit so that they're more specific with respect to the issues that are involved. And, you know, I guess that's what we're really after, is to make sure that in the end, that the applicant is held to a standard that we believe is necessary.
Okay, so it's my understanding that we as a board can, because the record is now open again, that we can make revisions to the resolutions that we have here. And I hope that revisions and tightened up mean the same thing as we go forward here too, so that we understand that this matter has been brought before us, and now we have the opportunity to, as a board, to review, but also to revise the conditions as presented last time, which were 6. Okay, so I just wanted to make sure that we were all on the same page on this discussion. Okay, so now I'm going to ask Frank a question. Does anybody else on the board, before we go into board discussion, have any more questions for either for Mr. Curtis or Mr. Acheampong? Okay, Hearing no questions, then Frank, hearing from this evening and what you've outlined from the board itself, or outlined for the Board of Appeals, that it appears to us that the pathway forward for the board would be to examine our conditions as presented last month and to address the concerns as presented by Mr. Curtis at tonight's meeting and revise the resolution. Is that a correct assumption?
Yeah, yes, if the board certainly has the ability to do that, that could be with the 6 conditions. I mean, we may want to probably ask Caroline to go through. There were 4 more specific concerns raised. I would want to make sure it is possible for the board to vote tonight, if the board's willing to say, let's add these 4 concerns within those 4 conditions. It might simply be revising a few of those conditions or adding others. That's the part I'm not.
Okay, so
would
having
help to actually see what
okay.
how that would be done, but if
I have a quick question.
Sure.
Oh, Gary, can I still have the floor, please? Okay.
Sure.
So my question, thanks. So Frank, so having the resolution in front of me from last month, the conditions were, as described by this evening, were conditions number 3, the maximum occupancy of 50 persons are permitted on site at one time. It's condition number 5, no childcare shall be provided.
Actually, Madam Chair, that sounds like we have just answered Mr. Curtis's question. He said that he thought the resolution from last month may have allowed attendance to 50 and actually limited attendance. And he said he thought it allowed 60. In fact, it allows 50. And that is, I thought that's what was approved. So that should answer that question. 50 actually is the limit that was approved.
Yes. Okay.
Thank you.
Okay. All right. So I think we have, I think for the board's sake, and then Gary, I'll let you go ahead and ask your question. For the board's sake, that we can go through the 6 conditions as we presented, as we voted on last month, and maybe we'll have to add a 7th as part of tonight's discussion. Okay, Gary, go ahead.
Well, I was going to ask Caroline, are you able to put on the screen the 6 conditions?
There you go.
So we can review them?
I think we can put, well, they're on 2 different pages, unfortunately, in the resolution, but most of them are on packet page 179, except for the first line of the first condition, which I don't think really is of any consequence for this discussion. So I don't know if we can pull up the page 179.
And so Gary, just to follow your lead, we will now go through the conditions and ask for the board to revise based on the information we heard this evening, correct?
Well, and yeah, I mean, I think to Frank's point is, I think some of this might already be answered in those conditions.
Yes.
I just wanted to see them, so we don't have a condition on top of a condition.
Okay. Okay.
I'm not sure if they're not able to pull it up or.
Yeah, you can. I just went off your email. It comes right up there. So.
Off my email.
Well, the original with the direct link to the site.
No, I have no control over the packet. It's an IT issue. We don't have access to it to pull it up on.
Or
on
they would
Zoom.
have to get that page. You said it was page 179 of the packet?
179.
Packet page 179.
179, that's what you need. And that would show everything but the first line
Right.
of the first condition.
Right.
Correct.
Yeah,
Right.
that would be easy to walk through pretty quickly, I think.
So while we're waiting for that to come up, let's
We
just
can do it.
start.
We
I can read
it
them to
condition
you.
by condition too.
So the first, just for the sake of discussion, the first condition was this special exception is
Oh, there we
granted.
go.
Okay, so the sentence before says this special exception is granted for Restoration Chapel International only and shall terminate at the time of this religious use ceases to operate at that location. Any
Okay.
comments on changing? Okay.
5 and 6 are the main concerns.
Okay, well, I would just like to go through each one if
Okay.
that's okay, just
Okay.
for the sake of order and thoroughness. Okay, all right, so we did state church assembly hours are limited to the hours specified in the petitioner's statement, which was Exhibit 2. And I do believe that was only on Sunday and on Thursday. Was that correct?
The assembly use was limited to just to Sunday. There were meetings on other days, but believe assembly.
But
use-
not assemblies.
Correct. So assembly is just Sundays.
On Sunday.
Sundays. So there should not be any services held then on Tuesdays or Thursdays. If so, it would need to be brought before the board and we'd have to adjust.
Well, it would be a violation of the conditions.
That's
Correct.
correct. That's correct.
In other words, if they wanted extended assembly hours, the applicant would need to come back for a revision to the special exception. If they're operating an assembly, a service, a full service outside of the specified hours, then they would be in violation. That doesn't mean they can't come back to the board and request additional hours, but that would be a process where, the adjoining neighbors would be notified and could testify and, would kind of reopen the case.
Okay.
And services are defined as funerals, any sort of assembly of the congregation. Not just a Sunday, any sort of, funeral, for lack of a better word, or that's not allowed, only on Sundays. Is that a fair statement?
The condition says assembly, so I suppose that would be up to somebody to define.
I thought I read that they couldn't have weddings and funerals. Did I read that somewhere?
That was their response.
Okay.
During the hearing on July 14th, there was discussion, and the record does show that they indicated, Sarah, as you said, that there would be no funerals or weddings at that location.
Okay. All right. So moving on to number 3, the maximum occupancy of 50 persons are permitted on site at one time.
Yeah. And that's actually a bit more restrictive than attendance at 50, because maximum occupancy includes speakers and some others as well.
Children, it's
Mhm.
50 total people, correct, Frank?
That's
That is
correct.
correct. Yes, sir.
Okay, so I think this is something where, let's see, number 4. I think no change there. Petitioners shall make all necessary changes to the property to obtain a use and occupancy permit for an assembly use. So I think it's 5 and 6 and maybe an addition of a 7.
Okay, could I
Yeah. go
comment
ahead.
on 4 briefly?
Sure.
I don't know if I did, was there something that there's been alterations did I read something in there where there's been some changes and maybe there was permitting not done? I don't know where I thought.
Oh, you're right. That was in the
something along there,
letter.
Maybe I,
Nope, you're right, Gary. That was in the letter that we received, and it was the electrical panel was indicated in the letter there.
I'll just interject that the applicant is working with the city permitting office to do what they need to do in order to get their use and occupancy permit. So whatever issues there are, they're working with the city.
Okay, so that's
And
already covered.
And
Go
I'm
ahead.
fine with that. I just didn't know if we should add that as part of that condition that, because apparently there's been some changes done without pulling permits, which just throwing that out there. I'm not saying it's necessary.
Any other comments from the board on number 4? Do we want to add prior to beginning of work or something like that?
They can't operate without a use and occupancy permit. So I'm not really sure what would add to that.
Well, and legally they are required to obtain a permit, and I've got a couple of municipal infractions cases we're handling where folks did work without a permit. So
okay, so
it does happen, but it's not legal.
Not legal. Okay. All right, so I think that one's covered. Do you agree, Gary?
Yes.
Okay. All right, number 5, no childcare shall be provided on site. And I do have a recommendation but I'd like to hear from the board first to add to this condition. And so,
Yeah, I think
go
that
ahead, Emil. Go ahead, Emil.
Oh, thank you, Carol. I think that Mr. Curtis's comment about children being in a parking lot or I guess common areas, that may not be covered under the existing condition 5.
Right.
Okay. Yes. I agree. And the suggested verbiage is, and children remain under adult supervision.
Perhaps within the confines of the building itself.
Okay. All right. Okay, so do we have agreement from the board?
That's fine with me.
Okay. All right. Number 6. Oh, this one, I'd like to hear from the board. I do have a suggestion for verbiage, but I want to hear first. So we say petitioner will be mindful of noise levels affecting adjacent units and will take steps to address noise level complaints from such units.
I can comment if you like, Carol.
I'm sorry, did you say something, Gary?
Yeah, I can comment if you like.
Okay. Please go forward. Yes.
Yeah, I just think that Peter needs to understand that the way this is written, I mean, it's very arbitrational. And so, where the sound levels may be fine right now for the current occupancies, when there's a new occupancy, there might not be. And the way this is written, they would be able to request a hearing as number 6. In other words, if Mr. Curtis sold his unit to a new owner, they might feel it's not acceptable, even though it was acceptable to Mr. Curtis, if that makes sense. I guess I just want to make sure that Peter understands that that's very open-ended in my opinion, but maybe I'm wrong. Frank could probably comment on that.
Okay, thanks, Gary. Any other board members?
Yeah, and to add to Gary's comment, Frank had cautioned us as a board, say, to adopt the condo board's bylaws as a condition, and had I heard a recommendation instead to consider something about applying noise retardant material, but that also wouldn't necessarily address Gary's concern that by even installing the noise retardant material, that would bring the noise levels to an acceptable level for the current and or future occupants of this condo park.
Okay. Okay. Thanks, Emil. Okay. Additional comments, Sarah or Robert, on number 6?
Nothing more.
Nothing more.
Okay, so the item, what I heard with our discussion, addressing and recognizing comments from both Gary and Emil, as well as Mr. Curtis and Frank, I heard sound mitigation as perhaps part of an additional add to this particular item to address the concerns that we heard this evening. So they'll be mindful. We'll take steps through sound mitigation to address noise level complaints from such units. So after we'll take steps to address, take steps to address, or something where sound mitigation can be added to that item number 6.
Yeah, we'll take steps, including, but the steps shouldn't be on complaint. Perhaps it would be, we'll be not mindful of the noise. We'll add the sound barriers under the windows on one end of the sanctuary to help buffer the noise, and then go into the last comment was, which was if there's a complaint to be, to address those complaints. And it's appropriate, the record, has the discussion from Mr. Curtis and from Tom and Peter, why don't we say it that way, indicating that there's an understanding of what that item is. And as a condition, if for some reason it doesn't happen, then that would be something that could be brought to the board to say, look, there's a violation of that condition.
So, so the board comment on Frank's suggestion for the verbiage for number 6. It's basically breaking it down into 2 separate sentences.
Okay.
Whatever it needs to be to make it sound easy to understand.
Okay, all right. So Caroline, did you capture what Frank had said as a recommendation?
I have it as just one sentence still, but
right, it is.
Petitioner will be mindful of noise levels affecting adjacent units and will add sound barriers under windows.
Skylights.
Under skylights to help buffer noise, and will address noise level complaints from such units, from such units.
Okay, right, because we referred to adjacent units in the first part of the sentence. Okay, one sentence. Okay, so that's item number 6. And then the one item that wasn't covered in our previous resolution and under the conditions was insurance liability. So I'm looking for some guidance on the board's responsibility to address insurance liability as a special exception, as a condition. So some guidance there, and if so, is there some verbiage that we can say for number 7 then?
If I may speak, Carol, I'm not sure that should be a condition. I think if the association should require all owners to provide liability insurance to protect their business. I don't know if we need to single out Peter's business for that. I think that should come from the condo board and the association. That's just my personal opinion.
Okay, thank you.
Carol, may I comment on that?
I agree with that. So I don't know what Frank, like what his opinion is, but I do agree with that.
Carol, may I comment?
Yes, please, Tom.
First, you must understand that none of the businesses have the kind of usage that this particular operation has. They have multiple numbers of people coming into the units. The other units, you may have 1 or 2 people coming in at one time or another throughout the day, but you certainly don't have 30 and 40 people coming into the units. And again, all of the unit owners have liability insurance to cover, somebody falling outside their unit or somebody falling inside their unit. What we're concerned about is the much larger number of people that are going to be inside this unit and the liability that is associated with somebody either getting hurt inside the unit or just somebody getting hurt outside the unit.
Okay, thank you. Then we'll look to Frank for some guidance on how this applies to this special exception within our realm as the Board of Appeals.
Yeah, I believe the applicant, Peter, had said that they had, actually, I'd like him to address that concern because I thought he had said that they would provide that information, but I'll let you speak, sir.
Yes, when we met the association, it came up, so we assured them that that's something we do. So I think that can be, we can sort this out with the association. If Tom, and I will make sure we show it to Tom as soon as we get it ready.
There may be a way to add wording. First of all, it's difficult to say it's the city's role to require one private property owner to provide evidence of insurance or something else to the other property owner, because that really is outside, as a couple of board members, Sarah and I think Gary had both mentioned, a bit outside of what the board really has the ability to do. That having been said, though, the board could certainly add a condition saying that the board understands that, without saying that anybody's required, because again, it's a bit beyond the board's ability, but to at least say that the board understands that the applicant will provide evidence, prior to opening, prior to having operating under the use and occupancy permit. And actually, this could probably be added to the comment dealing with the use and occupancy permit because it's a bit more relevant there. That there just could be an additional sentence on that condition to say that the board understands that the applicant will provide evidence of adequate liability insurance to the condo board at that time. That's not stated as a specific condition, but it is underscoring the discussion in the record, and that the applicant, it's not imposing a city condition, but it's certainly making it clear that given the use and it, as related to obtaining the UNO, that would be provided to the board. And it seems to me that would be going about as far as the city could go, but it certainly would include some language to address that.
I think that would be item number 4.
I don't remember if that was the second or third.
It's number 4. Number 4
on the UNO.
Yeah, number 4. Yeah. Okay, thank you, Frank.
I would just like to say I like that.
Okay, thank you, Tom.
Okay, I want to make some correction. Maybe maybe I didn't hear well. During I mean, the discussion, you said we will only have assembly on Sunday, which I think I gave you Sunday, Thursday. We during the last time we agreed that Tuesday wouldn't be like an assembly, it's just a meeting day, but it's Sunday and Thursday. That was the days I gave.
Yep. I stand corrected.
That's the existing exhibit 2, is that correct?
And the Sunday is 10 to 12, and then Thursdays is 8 to 10.
I apologize, I forgot that. Okay. I don't have the exhibit. We don't have the full set of exhibits up tonight, so, but you are correct.
Thank you.
Okay. Okay, so that looks like that we've covered then the matters brought before us this evening by Mr. Curtis and response by Mr. Acheampong. And in taking what we had approved, we reopened the record for this discussion and revised the conditions, which would be condition number 4, condition number 5, and condition number 6. Does that correlate with your notes, Caroline?
Yes, I do have one question about Frank's suggestion about adding on to Exhibit 4, the
item 4.
Condition 4, yeah.
That the applicant would provide the liability insurance to the city. Is that correct? I mean, I don't know that. I mean, then we can include it in the record, but would they be supplying that insurance to policy to us or to?
No, no. The comment was simply that the board understands that the applicant will provide evidence of insurance coverage to the condo board.
Okay.
Liability insurance coverage. It is not actually making it a condition.
Okay.
It's not something where, it has to be provided to the city, but it is underscoring the issue and including some language that it's the board's understanding that will happen.
And is that something that would be in that condition, or could it just be in the findings and conclusions section of the resolution?
It could either be there or it could be in the findings and conclusions. I think the important part would be to include the sentence as indicated that it's the board's understanding as part of the findings and conclusions would be another way. I didn't necessarily want to open that if we were looking at the conditions, but that could be added. Yes, that is one way to do it.
Okay. Okay, so if we did that, then we would be revising conditions 5 and 6 as part of tonight's discussion to address the matter.
And then because I assume if the board is willing, the motion should include the stated change to the findings and conclusions to add that sentence.
And the stated change.
Yeah.
Okay. Okay. So it's updating the resolution with the conditions 5 and 6 and adding and recognizing the stated finding the stated change for insurance. The board understands the need for the insurance coverage, and that would also be found in the findings and conclusions by staff. Okay. All right.
Can I ask one?
Yeah,
more
please.
question? I'm sorry, Frank. In revising this resolution, are we also documenting this evening's discussion and the history part? Does that get updated as well?
If the board, there has been a record and a discussion If there have been changes to the history part, that certainly could happen. But it would be more helpful to identify so that the board can include that in the motion. At this point, if we're looking to approve this tonight,
Yeah.
if there have been changes that should be referenced, at least indicating what it is, so that, again, the record's open, so.
Well, I
be
I
included
mostly
in.
just, I wanted to make sure when if we add a sentence to the findings and conclusions, that it doesn't look like that was part of the July 14th discussion. So if there's a way, when I draft it, to reference this meeting there, so that it does not look like, I mean, anybody that went back to July 14th is not going to see that part of the discussion. That would only come up if there's reference to tonight's meeting.
Yeah, the revised order would be, I mean, the revised order is not going to be dated July 14th. The revised order would be including, and I think maybe that addresses your thought,
Okay.
is that at least a couple of sentences to lay out what occurred.
Yeah.
The discussion tonight, that there was a motion to reopen. The applicant did respond, and the board decided to amend the conditions and add that reference.
Okay.
So that would be the background. That would have to be added because this order will be dated as of tonight, August 11th, not July 14th.
Okay.
So.
Okay, any other questions, Caroline?
No, that's good.
Okay, so it's my understanding then, Frank, the board needs to offer a motion that, because we've already reopened the record, so we don't have to do that.
Well, you might want to close it.
Yeah, we need to close it tonight, but we need to also offer a motion to recognize that we have updated conditions 5 and 6 with as we have already discussed.
And the findings and conclusion.
What's that?
And the findings and conclusion.
And the findings and conclusion, and also have added the requirement for insurance coverage in the findings and conclusions.
Or the reference.
Yes. So I wanted to make sure when I asked for the offer of the motion that one of the board members is able to say that. Because I think that's our next step at this point. Unless there's any further discussion from the board, I think we can go ahead and I can call for a motion.
And I would actually say in some cases, the chair can make the motion too.
Oh, all right. Is there anybody on the board that would like to make the motion? If not, I'll go ahead and make it. Okay, I don't see anybody coming off mute. All right, so. Okay, I'd like it to make a motion I think, Caroline, are we gonna use the same resolution? The case, I'd like to make a resolution to case.
I think
Okay.
You don't need to read the whole thing. You can just.
Well, I just wanted to reference what we were talking about. Okay, all right. So case BOA 87962021, that the following conditions 5 and 6 are updated with the as per our discussion, and insurance coverage will be included in the findings and conclusions. Is that everything? Okay, so then I'll ask for a second.
Second.
Okay, is there any further discussion from the board? All right, let's call for the vote. Okay, Gary, how do you vote?
Aye.
Robert?
Aye.
Emil?
Aye.
Sarah?
Aye.
And myself, aye. Motion passes 5-0. Now I think we need a motion to close the record. Can somebody make that motion, please?
I make the motion that we close the record, updating BOA 8796-2021.
Thank you, Robert. And a second?
I second.
Okay, all those in favor, I'll have to call you by name. Gary,
Aye.
Robert,
Aye.
Emil,
Aye.
Sarah,
Aye.
and myself, aye. The motion passes to close the record 5-0. I think we're done with that case. Okay, I thank everyone for their participation, but we're not done as a board yet with the meeting. Almost, we're almost to the finish line there, but thank you very much.
I'd like to thank the board for their consideration and thank you for the results.
You're welcome. Thank you.
And thank you too.
Thank you too. Thank you. Okay, so moving on now, item agenda number 4 from the staff. Is there anything you'd like to share with us tonight, Caroline, at 9:36?
No, just the next meeting is Wednesday, September 8th. We should be meeting again. We're very busy all of a sudden.
That's great. And Frank, anything you'd like to share?
I would just say that I know I think Caroline had said this might have been the first motion to reopen, at least in memory. And I very much appreciate the boards working together and also working with both the moving party and the applicant to come to a solution that seems workable for everybody. That's not always the way it works. And it was nice to sit here and be part of that and be able to help you through that. So.
Thank you, Frank. Appreciate that. Yes. And thank you to the rest of the board too. We had a hearty discussion, I think, on all 3 cases tonight. But is there anything from the board? Anybody would like to make any final comment before I call to close the meeting?
Nothing for me. To clarify, Caroline, our next meeting will be in person, as you mentioned before, correct?
No, sadly.
Oh, okay.
The city, I'm glad you asked.
Yes, thank you.
The city has pushed back we had planned to go back in person in September, and of course, as with everything, it seems like everything is getting pushed back. So September, definitely not, and the rest of the year is to be determined. So we will be on Zoom again.
Okay. All right. Anybody else? All right.
Thank you
Well,
for your leadership, Carol and Frank. I appreciate it. And also
thank you, Gary.
Caroline.
Okay. Well, thank you.
Thank you.
All right. So I know as chair, I can just call for this
Yep.
meeting is now adjourned. And so there you go.